Today, we are talking about offers to settle and settlement in personal injury actions. I'm going to answer 3 frequently asked questions so that you can get a better sense of how the settlement process works for your legal matter, so you have some insight into that. I'm Natalie Gerry, the principal lawyer and founder of Gerry Law. I help injured people get the compensation they deserve for their injuries. Let's get into these topics today. A settlement in the litigation process is quite common. Approximately 95% of cases do settle. The first really common question that I get, though, is when does a case usually settle in the litigation process? The answer to that is really it varies, but the most common time is after discoveries are completed. And I do have a full video that will be linked below about what a discovery is and that process. But in a nutshell, the discovery is when both sides get to see the strength of the case against them. So both sides have an obligation to disclose, first of all of the documents that they have in their possession related to the case. And then secondly, the parties get to sit down and ask the other party questions about the incident and what happened and their injuries and the aftermath and that kind of thing. And also the plaintiff's lawyer gets to ask the defendant about what they did to avoid the injury, and that kind of evidence comes out. So after the discovery process is finished, usually the parties have a good sense of how strong the case is against them, and they may look to settle. The other time that the file might settle is after the expert opinions are obtained. So this would be between discoveries and then pre-trial. So this is when the parties would go out and get an expert about, say, whether the defendant met the standard of care. And it is common for the file to settle after those expert reports have been delivered. After discovery, the defense and the insurance companies usually have a clearer picture of what happened and the extent of the injuries. And then this is where they're more likely to make a higher offer to settle on a case. Settling too early can be risky for an insurance company because they might not have all the necessary information about liability and the injury's future implications. So if they offer settlement before the discovery process is finished, then the insurance company might feel like they are overpaying, or they may miss out on defenses that could be raised after they have all of the facts. So usually once the insurance company has a more full picture of what happened and the risk against them, that's when they're more likely to offer settlement. The second question that I commonly am asked is how many offers and counter offers are typical in settlement negotiations? So this is a good question, but again, it really depends, and every case is different. I would say no two cases are the same at all in this regard. The answer is nuanced and depends really how clear-cut liability is usually. If liability is very clear-cut, then it's possible the parties might be closer together, at least understanding that some amount is owed to the plaintiff. But then again, you can be really far apart on the damages assessment. So it really does depend. You can think of it like each party is sculpting a sculpture, so it goes back and forth, and you have to just continue working on the sculpture until both sides are happy with it. An example, I have had some files where liability is very clear cut, like there's no argument that the defendant was not liable. And so some of these cases I've been able to negotiate a resolution even before discovery. But on the other hand, there are some cases where even though liability is clear cut and we've negotiated back and forth, at least 20 offers and counter offers, and we're just back and forth and just can't get to the resolution. So in the case I'm thinking of, we prepared everything and we were just about to go to trial. And on the morning of trial, I got a call from the other lawyer with an offer to settle and brought it to my client, and they said, okay, let's settle this. So it can settle, going back to question 1, at any stage in the litigation, most commonly after discoveries, but it can be at any time. In my experience, the back and forth between the parties, though, gives a good indication of how serious they are about actually settling the matter. If, for example, the insurance company is coming in at like $5,000 and the plaintiff is valuing their claim at $500,000, it's very unlikely that there would be much room to negotiate. And if you think of like meeting in the middle, it's just not feasible when the plaintiff has 500,000 arguably in damages. So it can be difficult when the parties are that far apart. Another question that I get somewhat often is an old school rule that comes up, and it's called the rule of 3. And so I have people ask, is this a rule that I go by? So this rule suggests that the initial offer is about 3 times what you expect the case to settle for. So for example, if you ask for 75,000, then it means that you might be expecting the case to settle for around 25,000. So this is not a rule that I personally go by, and I don't know that many lawyers do. I think for the most part, at least my practice is when I put forward an offer to settle, I justify all of the numbers in the offer, so they all have justification. So I wouldn't be justified necessarily in inflating them to 3 times what I thought the case would settle for. So the answer for me to this question is no, I don't do the rule of 3 where I'm inflating the first settlement number. I really go in justifying every single number we're looking for. Otherwise, I think you do lose a bit of credibility with opposing counsel in terms of what you're looking for. So there we go. Those are 3 of the top most common questions that I do get asked about settlements. If you have any other questions for me, please leave them in the comments below and I would be happy to answer them. Please subscribe to my channel and check out my other videos.